Good afternoon. Calling the case of Carter versus DTN Management Company. This is a 20-minute grant. You both have 2 minutes of a free fire zone, and you may reserve time for rebuttal. We ask that you keep track of your own time if we don't use it all up, and you may begin when you're ready.
Good afternoon, Your Honors. May it please the Court. David Nelson appearing on behalf of the appellant DTN Management Company. This case concerns the issue of whether this Court had the authority to issue administrative orders 2023 and 2018, which told legislatively created statute of limitations. Appellants and DTN submit that this Court did not have such authority because this Court does not have the authority to modify substantive legislative enactments such as statutes of limitation. To the extent that there is a need to create a tolling mechanism in times of a pandemic, that is a legislative determination and not a determination that this Court is to make. This Court has held that statutes of limitations are comprehensive and exclusive, and that follows from the legislative scheme that enacted statutes of limitation under the Revised Judicature Act. They set forth times when lawsuits may be brought. They set forth under what circumstances tolling can exist to toll a statute of limitations, and courts have held that the fact that the legislature set forth those exceptions and those tolling mechanisms is legislative intent, that they only intended those tolling mechanisms to serve as mechanisms. Statutes of limitation also reflect underlying policy considerations apart from mere practice and procedure, those being prompt recovery, penalizing plaintiffs who have not been industrious in pursuing claims, security against stale claims, prevention of fraudulent claims, and remedy inconvenience associated with delay in asserting a legal right. This Court in Driver indicated that statutes of limitations create substantial rights for defendants, and that's clear from the fact that it is intended to prevent stale claims from being asserted against defendants. The plain language of the statute is controlling, and judicial tolling is not allowed. This Court has repeatedly held that judicial tolling of statutes of limitation is not allowed, and the tolling orders, in this case the administrative orders, in reality constitute judicial tolling. The statute at issue here, MCL 600-5805, provides a 3-year statute of limitations. It states that a person shall not bring or maintain an action unless it's commenced within those periods of time. This Court has also held that the language and the words of the statute is what citizens look to for guidance in conducting their behavior, and not administrative orders. The Court has recognized also in de Villers that this Court cannot substitute its judgment for that of the legislature in interpreting clear and unambiguous statutory provisions. Here, the administrative orders exceed this Court's constitutional rulemaking authority. The legislature did not see fit to toll statute of limitations in times of a pandemic, and it was not up to this Court to make a determination that statute of limitations should be tolled in such times, as that is ultimately a legislative determination. The Supreme Court has the power to say what the law is and not what it ought to be. By enacting the administrative orders, this Court substituted its judgment for that of the legislature and inserted a new tolling mechanism that was contrary to the plain language of the statute. This exceeded their authority, this exceeded this Court's authority, and therefore the Court of Appeals' decision should be reversed and the trial court's order granting summary disposition in favor of appellants DTN should be affirmed, and I would invite the Court to ask any questions that they have.
Oh, I'll bite, I guess. I guess this is more for the other side, but what do we, if your side was to lose, would that mean we'd have to overrule our Gladich? Would we have to overrule that case?
I mean, I think if Gladich clearly stands for the proposition that the statutes of limitation are substantive. I mean, I think that follows from prior case law. I don't know as if you'd actually have to overrule Gladich, because I think there is adequate language indicating that statutes of limitation are substantive even apart from Gladich. So I think, I don't know as if you would necessarily have to overrule it, but I think Gladich definitely supports the contention in this case that they are substantive, and it's based on the fact that the statutes of limitation reflect underlying policy considerations.
And what do we do about the fact that this court adopted these orders, if we believe they're unconstitutional? The argument is, of course, that we then misled the pleading public, and they followed these unconstitutional orders, and shouldn't they receive some sort of equitable consideration for that? What's your response to that?
My response to that, first of all, is that this court in particular, has indicated, and I think this was in the Pahutsky case, probably not pronouncing that right, but in discussing, and it indicated it's well to recall that when dealing with an area that is statutory, that it is the words of the statute itself that a citizen first looks to for guidance in directing his actions. I mean, the statute is clear on its face, and it's clear and unambiguous. And
I don't think that gets to what Justice Viviano asked.
Right, it's not the statute that would invoke the equity. It would be the words of our AO, right?
Right, and so, I mean, I guess what I would say to that, and if this is related, so one of the arguments was raised, it was in Bryant, where the courts create confusion whether equitable estoppel can be applied to that situation. So what I would say to that issue is the fact where in Bryant, the issue was you had a law that was confusing because it was a judicially created idea of whether a case sounds in medical malpractice or ordinary negligence. In Trentadue, the court addressed that issue and said, in Bryant, the issue, no controlling statute negated the application of equity. Here, you have a controlling statute that negates the application of equity. And in Trentadue, it said, rather, this court's case law determined whether a claim sounded in medical malpractice or ordinary negligence.
Is there a difference, though, in that example when you have a statute and you have the court through an opinion saying something, and the court through an administrative order on process to all of the courts, all litigants, saying these are the rules that you must follow? That seems like a very different circumstance than when you have a statute versus a court decision that conflict.
Well, I mean, in response to that, Your Honor, it would behoove a litigant to understand that administrative orders that deal with matters of substance or which in effect modify statutes of limitations that conflict with clear statutory mandates with regard to statutes of limitations, that litigants would understand that under prevailing case law that the administrative order would yield to that conflicting statutory provision. And
Don't you think it would be very confusing for litigants and the public to see an administrative order come from the Michigan Supreme Court saying these are the rules, and then the expectation would be that attorneys, litigants all over the state look at that and say, oh, the Supreme Court said that, but I'm reading the statute and I think I've got to follow that instead. They don't have the ability to do that, even though they clearly think they have the ability to do that.
I think the one aspect with equity is you also have to pursue a case with reasonable diligence, and one of the factors with regard to that is whether you should elect to take your chances on an administrative order or file a lawsuit when the statute says 3 years, and 3 years is 3 years. And this court has repeatedly held that judicial tolling is not appropriate. Any lawyer who has been practicing understands that rationale. And the other factor, at least turning to this case, is the appellees had counsel as of 2018 in which they could have filed. So It's not as if this was an unrepresented litigant, which I understand the point, Justice Clement, that if it's the general public looking at this, yes, I could see there could be some confusion about what do we do here. However, when you've got an individual who's represented by counsel and who presumably understands these relationships and the case law that's been passed down, I don't think equity really provides a remedy here, especially when you consider DeVillers and the other courts that have, and the other cases that have said that doesn't apply when you've got clear and unambiguous statutory provisions.
You aren't making us feel any better here. The case law I found arguably supports the notion of equitable tolling of statutes of limitations when courts are closed. Do you agree with that?
I'm sorry, I didn't catch all that, Justice
The case law
Zimmer.
that I've been looking at arguably supports the notion that you can use equitable tolling to extend statutes of limitations when courts are closed. Do you agree with that?
The
Well,
response.
just accept that I'm reasonably accurate in my statement. Are we that far off here? If it's okay when it's closed, and now
I
you're
mean-
facing a pandemic of 100-year proportion, is it that much of an extension to say we're going to permit equitable tolling here, especially given what the court did?
So in the case where courts are officially closed, where they're not accepting filings at all, I think there is an argument that equity could potentially apply. However, in this situation, courts were not officially closed to filings. And in fact, the administrative order specifically said that courts were required to make arrangements to accept filings of pleadings, and in fact, all courts did. Ingham County Circuit Court had email filings. Cases and complaints were allowed to be filed and could be filed during those time periods. So this was not a situation where courts were closed to filing of pleadings or
I understand. I
complaints.
said, is it an impermissible extension under the circumstances of this pandemic to say equitable tolling is going to be permitted, given the court's action of saying we're going to extend these things?
Yeah, I would disagree. I would say that it's not permissible given the pandemic, even though courts are closed to foot traffic because they're still open to filings, and there's a clear.
Were all of them? I mean,
I'm sorry.
were all of them open? Were all of them, some of them may have been physically open, some may not have been, but might have had means to electronically file, some may not. Are you suggesting that what we should have done is to have gone court by court, 242 different courts throughout the state, and said, well, here's what you should do or not?
No, I'm not suggesting that, Your Honor. I mean, what I'm indicating is that the administrative orders specifically indicated that the courts shall have the ability to accept filings, whether they're by email or, so they loosened up those requirements. That a court that's traditionally not a paper filing court, they made arrangements to have email filing. So I can't answer your question of whether all courts actually did that, so I don't know the answer to that, Justice Kavanaugh. But the arrangements were made to accept filings, and in that sense, given the language of the statute, I don't think there's a basis for equity.
I mean, I don't know if you recall, but the uncertainty of the moment, you weren't quite sure whether the courts would be able to open. You would turn on the news and see people lying on gurneys outside of hospitals because they could not get in there, claims that people were dying. So the exigency of that, we're going to try to keep the courts open, but here, we're saying you've got this extra time. In an unprecedented situation, how do we not find some equitable way of providing a fair and equitable result here?
I understand the considerations that this court was facing at the time and that the executive was facing at the time. It was an unprecedented situation, but at the same time, the legislative mandate from the constitutional mandate is that the legislature is the body that has the authority for enacting substantive law. This court does not have the authority I understand there are exigent circumstances, but this court did not have the authority, and this court's prior precedent clearly established that even in the case of unfairness,
We have
of
the
blanket
authority and the duty to run the courts.
And we have superintendent control. Is that limited to just cases?
Well, I would say that, yeah, superintendent control would not be the applicable rule here because there is a specific statutory provision that governs the powers of this court's rulemaking authority, and that's separate from the superintendent control provision. So that's more specific to the issues at hand, which would be the issues which would be the rule that really governs rulemaking. And in that, the legislative, I think that's 600.223, in that provision, there is nothing in there that indicates that this court has the authority over tolling statutes of limitation or enacting substantive enactment. So I would say that superintendent control does not control the situation here, Justice Clement.
Do you want to reserve time for rebuttal? I don't see any other questions right now.
No, thank you, Your Honor. I'm good.
You do not want to reserve time for rebuttal?
Correct.
You-
Well,
you do
do
want
I
to.
have time? Actually, I'll
have
reserve.
4 minutes
I'll
left.
reserve 4 minutes for
Okay,
rebuttal. Yeah,
thank you.
thanks.
Good afternoon, Your Honors. May it please the court. Tim Seeger on behalf of Plaintiff Karen Carter. I think Your Honors already have identified the clear impact that COVID has had and the underlying basis for the necessity of these orders. I'll start where the justices were just asking questions with the rule that is the Supreme Court has a general superintending control to take any action it deems proper to facilitate the proper administration of justice. Supreme Court has authority over the practice and procedure of this state. It is through these powers that this court enacted the administrative orders. The orders were issued as the court has identified one of the most uncertain times, not just our state, but the nation has ever faced. These orders set forth clear rules that apply to both plaintiffs and defendants with regards to the computation of time as to when initial pleadings need to be brought. There's much discussion, much briefing about this court's powers, procedural and substantive, that relates to the statute of limitations. I feel it's very important to start where the justices were asking questions of my brother counsel, which is the potential impact if this court is to determine that it did not have the constitutional powers to enact these orders. That impact, it would mean to say to every single plaintiff in this state that relied upon an order from the Supreme Court that you were wrong. You didn't have the time that was afforded to you by an order of the Supreme Court. I can think of no greater injustice than telling the people of this state that they no longer have their claims, access to the courts, or a right to trial simply because they followed an administrative order from the highest court in this state. It is due to this potential injustice that no matter the determination with regards to the constitutional powers, which we continue to represent, this court had all authority to enter these orders, that should the court make that determination, and this gets to Justice Viviani, your question with regards to Gladich, that it's not necessary to overturn that because we do have rules of equity in which we can preserve to ensure that injustice is not faced by countless individuals across the state.
You kind of blended up all the issues in the case in a way that I find to be a little bit confusing. I don't think you're conceding that the court's orders were unconstitutional, are you?
No, Your Honor.
So what do we do with Gladich? Our statutes of limitation are substantive. The court doesn't have rulemaking power to change the substantive law. That's what Gladich says, right?
That is what Gladich says, and that is the current position of this court, correct. Now, with that said, I think there's two positions.
Before we get to remedy, just on whether the rules are unconstitutional, and I'm very sympathetic to what you're saying, but as I was sitting here listening, I was thinking, if I was a citizen and I relied on a statute that was later found to be unconstitutional, I'd be pretty unhappy then too. So things happen in a society where we have, a fundamental law that can trump subsidiary lawmaking by the legislature or rulemaking by this court.
You're correct, Your Honor, and candidly, that would possibly invoke a due process violation, and especially as it relates to prior instances where the legislature has lessened a statute of limitations. The court stepped in and said, well, we're still going to afford you that time. And so I think there's many of avenues of which the judiciary is able
Those
to.
are, you're sort of on remedy. I'm just trying to spend a minute or two talking about what you think about whether the orders are unconstitutional. So you don't think we need to overturn Gladich, I guess, if we go this equitable route, but that assumes that it's unconstitutional. What's your best argument that the orders are not unconstitutional?
Under the theories of Gladich, and if it were to be construed as a tolling, it would be construed as unconstitutional, as Gladich remains today. I think the position with regards to as taken in the amicus brief of the Michigan Association for Justice is that Gladich was improperly decided and improperly relied upon McDougal. I think when we look to the long-standing history with regards to this state, with regards to the orders that came from this court, statute of limitations have always been deemed to be procedural. And when
Okay,
we
so,
look-
so you do think we have to overrule Gladich if we were to find, it sounds like, if we were to find that the orders were not unconstitutional, they were constitutionally valid.
Yes, from the constitutional perspective, yes, that I believe to come to that conclusion with regards to whether or not we have that control or this court has that control, it flips then to the how question, as demonstrated throughout the briefing, as to how an individual comes to court rather than a legislative right.
You haven't asked us to overrule Gladich, have you?
I have not, Your Honor, no.
All right, so focusing on remedy, other than Bryant, is there any other examples of this court exercising the type of equitable tolling that you're asking us to do in this case?
Not that I'm aware of, Your Honor, no. I think Trenadu did a good application, and I think it's distinguishable. And in fact, that's in one instance which they did not apply equitable tolling. But I think it is appropriate under the similar Bryant standard as to which it came forward.
The Bryant involved confusing case law. I guess the distinction here is that the AOs, the administrative orders, were not confusing. The issue is if they may have been unconstitutional, right? So if we find that they're unconstitutional, isn't that a distinction from Bryant and the confusing case law scenario?
I think the similarity between Bryant is, again, as much as it's case law, it's the judiciary speaking. And it's a similar instance which we have here, which is the judiciary spoke. It entered an order. In Bryant, that order was, you don't have a med-mal claim, you have a negligence claim. They relied upon that. And the court then later came back and said, just because you relied upon the court's order, you shouldn't be punished for that. And I think that's where the similarity draws, is that we shouldn't be punishing individuals because they relied upon the highest court in this state's orders. And so I think there's a bit of a distinction there with regards to, as you're saying, it was based purely in case law. It was, in both instances, the judiciary speaking and an understandable reliance from a litigant on the order that came from that court.
I'd like you to assume that the administrative orders were issued with the best of intentions, since I was one of the people who voted in favor of them. Doesn't it create a strange scenario where maybe the legislature had the best of intentions when they passed a law, but it's our job to look at those laws objectively and sometimes strike them down if they violate the Constitution? In other words, isn't it a little self-serving to say, well, we're all good people up here, you know, nobody was trying to hurt anybody, and so we can do unconstitutional things?
I think it raises an important point. That's true, and in all fairness, Justice Viviano, why you raised this issue in Browning as to why the court should look at this, that even if we have the best intentions, we should still be asserting it. It's a great function of our government, that we should be evaluating our claims, some part in hindsight, but that just simply because...
But by the way, I think also as lawyers and as human beings, to be able to evaluate honestly whether we've made mistakes in the past and address those mistakes. So I think it's a good practice across the board.
And it's precisely that I think what we're taking then is a fact-by-fact approach, a situation-by-situation approach. And I know oftentimes, as we're facing with many of the arguments that this court's facing with regards to the COVID pandemic, it's quite easy to fall back on, it was a crazy time, we didn't know what we were doing. And I know that can be a dangerous thought, where just simply because either the governor spoke or the judiciary spoke, we should be able to evaluate that. But we should then be looking at it circumstantially, taking all factors in consideration, and that simply because we speak here doesn't mean that for all of time, the judiciary can simply toll a statute of limitations, extend a statute of limitations, change the rule for computation of time.
Now you're sort of on to my point, all the buildup I gave, all that drama, which is why not, to your last point? What incentive is there for us to be careful when promulgating rules or administrative orders if our constitutional mistakes are not going to be, we're not going to be held to account for those?
Not gonna be mistakes.
Yeah, they're not mistakes, or at least there's no problem. We can make whatever mistakes we want. What incentive is there for us to be careful?
And Your Honor, I think that that's answered best in, I guess, maybe a hopefulness and a wishfulness that the honorable justices that sit on this court, we have checks and balances. There's a reason there are 7 of you and not 1 of you. And that, yes, there may be some individuals that sit in these and hear these orders and say, I was absolutely right, I should never be wrong and should never be questioned. But I think that goes to the very facet as to why we have the judiciary, why we have checks and balances, and gets to the primary theme with regards to, let's evaluate this. You may come to the conclusion I was right. We look at the entirety of it, and you may come to the conclusion I was wrong. But I think that's the entire foundation of our judiciary, is to be able to evaluate that.
Let's just talk for one more minute about this. So we decide, we made a mistake. It's unfair to plaintiffs who relied on our mistake. We're gonna apply our orders, even if we think they're unconstitutional. What legal principle does this case stand for? Because we'll have to write an opinion to that effect, and that opinion will be precedent for lots of future cases. So what will this case, what will people look to this case, what will they conclude?
So there's realistically 3 avenues of which, if there's a determination with regards to as an unconstitutional power, there's 3 avenues of which I see coming to that conclusion. One, it's that it was the rightful power, MCR 1.108, because the courts were closed, and I'm happy to discuss that analysis there. There's additionally then the prospective versus retroactive application that the court can utilize.
But you're confusing me. Are you back to whether it was a violation or not?
Your Honor, yes, as I understood the question, which is, what does the standard stand for? What is
What would the case, what precedent, what legal principle will we establish in this case if we rule in your favor? That's the question. And meaning that if we grant, I'm sort of moved on beyond whether it's unconstitutional. If you have other arguments, I'm all ears there. I think we need to hear as much as we can about this case. But if we grant your client relief, equitable relief here, what legal principle will this case stand for going forward?
I think equitable tolling would be the principle of which it would be underlying, and that the judiciary in certain times has the control or has ability to make rulings deemed in equity. And that in my opinion, the decision should be narrowly tailored with regards to circumstances, primarily when the courts were closed, which then turns us back into the MCR 1.108. And so I think the theory of equitable tolling in this limited circumstance, taking all the factors inside, I mean, I don't think a ruling should be so blanket just to simply say, well, whenever we so determine, we can close courts and that won't count for your time. I think as it's narrowly tailored for the principle that it will stand for is there was not an equal access to courts. And as a result of that, we need to look at what ability we have to ensure the protection of justice, and then a factual analysis based upon each circumstance. Because we do have this issue in the lower courts where sometimes things are applied, discovery rule, equitable tolling, things of that nature, that we need to make sure we're accurately setting up that proper framework. And so I think it will stand for the position of, when we are faced with certain situations, we come to the judiciary, we discuss them, we have an analysis with regards to what that's going to be and how that's going to look like. I think the standard is under equitable tolling if it's a determination. Yes, sir.
Going on equitable tolling or case-by-case basis, assume that we conclude we didn't have the authority, it was unconstitutional, but we're going to try to find a method of granting some equitable relief on a case-by-case basis. Why would it be appropriate here, where the state of emergency did not prevent your plaintiff from filing her claim? The state of emergency occurred 2 years after plaintiff's injury and ended several months before the deadline for filing. So you could have filed any time in the 102-day period. You could have filed any time between January 22, 2020 and January 10, 2021. And this would have been a statutory guideline. So how is it wrong for the trial court here to have said you're really seeking a windfall and taking advantage of this rule?
Your Honor, I think the underlying nature of that question brings in what I would call a dangerous precedent to be set, that we're now going to be asking individuals why they waited until the last day of a 3-year statute of limitation to bring their claim. We generally speaking don't ask individuals why you wait a certain period of time to file a claim barring latches.
We generally don't enforce things that we find to be unconstitutional.
I certainly understand that position, but in this instance, I mean, I'll take the perspective for me as I practice in my practice. I know a statute of limitations is coming up. I call the client and say, hey, we've got an issue coming up. We've got a statute of limitations. There's a number of reasons we wait to file. Maybe it's for an overturning on open and obvious. Maybe it's because we're assessing an injury that we yet don't have all the information for. Someone simply doesn't want to come to court because, hey, coming to court's not the most favorite thing for litigants in the world. That I would have had a conversation 110 days prior to this close. To now say, to unravel that and say, well, you relied upon us, that's not gonna stand, I think is a concerning position to take, that we're now questioning why people don't bring claims to a certain period of time. And so I think from that perspective, looking at the, well, you could have filed this, it then takes then additionally outside of that to the individuals who couldn't file. And that's where this opinion has a much larger reaching. To Justice Kavanaugh's point with regards to the different courts and different systems, I don't think we want to be put in a situation where we say, hey, Ottawa County, you had my file. That's great. So your statute of limitations begins right there. But Keweenaw, you didn't have something set up until about May 30th. And then, you know, we did have some issues. I mean, I'll speak to myself. We had, in Kent County, we had filing where I walked into a court, gave it to a bailiff, he put it in a box and took it upstairs. I can think of at least 3 instances where I then appeared for a motion hearing and the justice said to me, Mr. Seeger, you didn't respond to the motion. I mean, we can't look at this through hindsight with that every single individual in this state had pure, clean access to the courts, because it's just simply not true. And even when we did first start this, I mean, I'll go back to my, again, own experiences. I wasn't sure if it was a fax or an email, and I'd try to call a clerk. I couldn't get a hold of a clerk. Staff wasn't there. We all did the best we could, but I think that's why it's so important, especially for these administrative orders, mainly from the equity perspective. We need to look at this through the first 100 days. Because this was a state of, I couldn't go to the courts. I couldn't go in and talk to a clerk. I couldn't pay a fee. Half the time I was mailing a fee, hoping they received it so that my motion would be deemed timely. And so I think when we look at it through that lens and from that perspective, it's not just Ms. Carter. This is now dealing with every single person across the state who relied upon these orders through those first 100 days. I will briefly touch, Your Honor, with regards to the issue with regards to retroactivity and perspective. I think the court's very clear, and we understand that generally speaking, retroactive application is the fallback, is the general rule, with the exception of when injustice would be met. And that's such a case that we have here, that if we don't apply this prospectively on a determination of unconstitutionality, there's simply no way to say, again, coming back to my routine position, which is there was adequate reliance upon the order from the highest state in this, court in this state. I think Justice Kelly hit it very well, that we were effectively, to rule otherwise and now to effectively punish the plaintiff, is to say that attorneys were ineffective in their counsel, that I should have seen this administrative order, as the defendant has suggested, and said, Supreme Court doesn't know what they're talking about. You don't have those extra days, and I don't need to have that conversation with you right now. I think that's a very dangerous precedent that we're setting, and that's why we look to these different cases with regards to their application. You know, I think when it gets back to equitable tolling, to just touch on that, with regards to court closures or inaccessibility, unusual circumstances or confusion created by the courts, it's very clear that that policy stands for that it would allow us to apply that here today. And I think we look then to Trenadu, and the reason I think it's so important to distinguish Trenadu is because there they were applying the discovery rule to, unfortunately, someone who had passed away. They had said the claim accrued the moment the person passed away. You didn't get the benefit of DNA to later learn 16 years down the road. They said there, the court did, this court said, the discovery rule does not lend itself to detrimental reliance. And for those reasons, plaintiffs seeking to invoke the rule do not bring suit because they expected to rely upon the rule. That was the reasoning of which they denied equitable tolling. I think there can be no denying that there would be detrimental reliance from the plaintiff, because I believe as this court entered the orders, constitutional or not, as we're getting into that analysis, there was an expectation that not just plaintiffs but defendants would rely upon this order. I mean, I think it's important to note, I couldn't meet with clients at this time. I think it was actually a crime if I did try to meet with a client face-to-face. I couldn't have a client come in, give me documents, assess it to file a complaint. And in the inverse, defendants weren't able to adequately investigate their answers to complaints. This was a benefit for everyone saying, You can't do your job, attorneys. This is going to be very difficult. The courts are figuring out a system which we have, and therefore it benefited everyone evenly. The difference is that if we were to determine and divest Ms. Carter of her claims, that she no longer gets her day in court. I don't get to go back because an answer was untimely filed by a defendant and enter a default. The inequities here are just unsound. And, you know, for those reasons, you know, I stand on the position that this court had the proper power to do so as a computation of time. The courts were closed. There's no denying that I physically could not go into a court. There's no denying the difficulties that were to be filing an action. With the court closure, this also gets to how we get around the constitutionality issue if it is deemed to be unconstitutional, is that this was a proper use of the computation of time as it relates to court closures, and that this court has that power inherent in it for the proper administration of justice.
That would
And-
mean that it's not, just so we're clear, that it's not unconstitutional if we accepted that argument, right?
Correct, Your Honor. As I go through the constitutional, unconstitutional analysis, I focus more on Gladich, but again, I believe that's where we don't have to get to that decision, is when we simply focus on the court closure aspect and the computation of time. It's an inherent power of this court to ensure the proper administration of justice at a time, as Justice Kelly said, the whole purpose of the orders was to limit face-to-face contact. And so for those reasons, I believe that this court should affirm the lower court. And if there are any other questions, I'm happy to answer them.
I don't see any. Thank you very much.
Thank you, Your Honor.
So, first of all, with regard to the computation of time argument, the 1.108 was intended to only essentially codify the common law rule that existed, that you include or you omit the day of the event, and then you include the last day of the event. So it was purely a computation of time. It did not involve excluding extended periods of time from that computation to essentially toll substantive legislative enactments. Now, turning to the retroactivity argument, first of all, reversing the Court of Appeals in this case would not establish a new rule of law. In fact, what it would do, it would actually do justice to the plain and unambiguous statutory language that's set forth in the statute of limitations. So there really, if you look at reliance interests, the reliance interest is really the ability to rely on statutes of limitations that this court has held is equally valid and in de Villers has established. The other issue with regard to whether litigants relied on the administrative orders versus the statute, I think it's important to note that in 2020, in the Midwest case, it was certified by the federal court. This court had determined that the governor's orders exceeded the legislative, or usurped essentially the legislative power, which called into question the governor's orders that this court's orders essentially tracked. So there was significant questions about whether the administrative orders, contrary to legislative enactments, were valid to begin with. So I think that causes pause in terms of an estoppel argument of, should the public really have relied on this, or should attorneys really have relied on these administrative orders when the clear and unambiguous statutory language says otherwise, and when this court had the opportunity to weigh in on whether the governor's orders were constitutional or not, and indicated they were not. So with that said, DTN respectfully requests that this court reverse the Court of Appeals and from the trial court's summary disposition, if the court has any additional questions.
I don't see any. Thank you both. The case will be submitted.
Thank you.